Every will, whether simple or complex, is generally comprised of 9 sections. There's an introduction identifying whose will it is, and there's a statement revoking all prior wills. There's a section naming family members. There's a section naming a personal representative, also called the executor, who is responsible for carrying out your wishes, as well as a statement as to whether you will require this person to post a bond. There's a section giving specific gifts to specific people. And there's a residue clause that disposes of all property not specifically mentioned in the will. There's a statement indicating how long a beneficiary must survive in order to receive a gift. And there's a section usually directing the handling of your final remains. Finally, there's the signature, witnessing, and attestation clauses. Additionally, if the person making a will has minor children, there should be a section nominating a guardian for the minor children. The introduction to a will identifies who is writing the will. It should state your full name, birthday, and the town where you are now living. It is not uncommon for people to write several wills during their lifetime. Therefore, it is essential to make it very clear that you are revoking any previous wills and that this will expresses all of your wishes as to how you want your property divided after you die. Identifying your family is very important to ensure your will is honored as written. Remember, one of the factors used to establish whether you were of sound mind when you signed your will is whether you were able to fully identify your family. Consequently, you should list all of your family members so that if you choose to leave somebody out of your will, it will be harder for him or her to suggest that you simply overlooked them in the gifts section. If you want to disinherit somebody, you can do so. We'll talk about that later. What is important is that the court knows that at the time you signed your will, you knew who your family was and that your gifts were intentional. Thus, you should identify every person to whom you've been married, and if that marriage has ended, how and when the marriage ended. You should also identify your children, their birthdays, where they live, if you know, and whether they are natural, adopted, or stepchildren. An example follows. The personal representative, also known as the executor, is the person who administers your estate. This is the person who will handle your business and put your affairs in order after you die. He or she will pay your debts from your estate and distribute your belongings according to your will. The personal representative is not personally responsible for paying the debts of the estate out of his or her pocket. When deciding who to choose as your personal representative, the most important thing is to choose a person you trust, as well as a person who is willing to serve. Since this person may have to work with a lot of people in Alaska, it is recommended that the personal representative be a resident of Alaska. The law requires a personal representative to post a bond, unless the will waives that requirement. A bond is basically an insurance policy that protects heirs and creditors if a personal representative mismanages the estate. Generally, we recommend that you waive the bond requirement for your personal representative, since the requirement can be expensive and bonds can sometimes be difficult to secure.